And so you just press A, B, C, D, and then that will be the basis for a discussion that the presenter will have. Our first speaker is Julie Dinerstein. Julie is the co-director for Sanctuary for Families Project at the Bronx Family Justice Center. She also teaches immigration law at the School of Professional Studies at CUNY. Before joining Sanctuary for Families, Julie was at the New York Immigration Coalition, and she was an associate at Cleary Gottlieb Steen and Hamilton, and a law clerk to Judge Jack Weinstein in the Eastern District of New York. So please join me in welcoming Julie Dinerstein.
Good morning, everyone. So it is amazing to see so many people here, so many volunteers. I'm particularly excited to see many of my former students at the School of Professional Studies who are here volunteering, as well as other attorneys and community members who I've worked with in the past. So today our focus, or at least the focus of my talk, is going to be on the family-based reasons for immigration. So as many of you know, if you've worked on green card cases before, they're really, conceptually, you can think about getting sponsored for a green card application based on 4 separate reasons. There are really 4 big ideas. These 4 big ideas, and it's the way that I divide it up, it's not an official way to divide it up, but it's the way that I like to think about it, really can be thought of as a family-based reason, an employment or an economic-based reason that you're getting a sponsorship or self-sponsoring, a humanitarian reason, or the 4th and smallest is that you've won the lottery. It's true. So there are 4 reasons that you might be eligible to apply for a green card, but it's important to keep in mind that even when you become eligible to apply for a green card, and I'll be hitting this point again and again, as will other speakers today, even people who are eligible to apply for a green card may never get a green card, because being eligible to apply is really just the first step in a longer process. And green card applicants not only need to have a reason to apply, they need to meet all the eligibility criteria. There are a lot of reasons why someone who is eligible to apply for a green card might ultimately not get one. These reasons can include unlawful entry, unlawful presence here without permission, unlawful work, that's when you work, but you're not authorized to do so by immigration, and that includes on-the-books work, off-the-books work, and criminal activity. So there are a lot of reasons, and those are just a few of the many that might get somebody into trouble. What we're going to be talking about, again, during my talk, is the family-based reason, which you would think would be straightforward, close family, they sponsor you, but unfortunately not at all. The rules are quite tricky, and if it's the first time you're hearing them, it's going to be just hard to get your head around. There's really no way around the fact that it's just a tricky set of rules relating to family members sponsoring other family members. So I'm going to go over what I would call the rule of sometimes, because there's really no definite answer. And so we want to be careful when we're talking to people on the phone and they identify that they have a close family, they either want to sponsor a family member or that they have a family member who wants to sponsor them. It's going to be important for us to realize that there's not a hard, fast rule. Once you know who the citizen or green card holder is, that's never going to be enough to tell you whether they're going to be able to get a green card or not. So here are my rules of sometimes. Some U.S. citizens and some lawful permanent residents, also known as LPR green card holders, can sponsor some close family members some of the time. That's really it. Sometimes the family sponsorship and green card applications can be filed together, but in many, and what I would say probably most cases, the family sponsorship petition must be filed, and a number of years will go by before it is the time for the immigrant to apply for a green card. So it's usually, though not always, a 2-step process. Sometimes the sponsored family member is going to be eligible to apply for a green card here in the U.S. You're going to hear this expression again and again, adjustment of status. That's when you apply for a green card from within the United States. Other times, The sponsored family member is required to go abroad, or people may just choose to apply for a green card from abroad, even if they have an option to do either one. And when you apply for a green card from abroad, that's called consular processing. Unfortunately, there are a lot of times where the family relationship is just not going to be enough. So again, to reemphasize that there are many people who have an approved family petition. The family sponsorship part is good to go, but they're still not going to be eligible for a green card. As mentioned earlier, unlawful work, unlawful entry, unlawful presence, criminal activities, and here's another one I didn't mention before, lack of a financial sponsor. The not so bad news, still not great, is that in some cases, though unfortunately not all, a person can apply for a waiver application from here in the United States or abroad, and sometimes going abroad itself cures the green card application barrier. So sometimes there are waivers available, and sometimes the mere fact of going abroad to consular process makes the application possible. So here's our first case study. I'm going to read it to you. You also have the poll questions with you, and now's the time to get out your poll clicker mobiles, whatever they're called, and see if you can answer the question. So here's our case study. Sandra came to the United States when she was 4 years old. After finishing college at the age of 23, Sandra married her long-term boyfriend and high school sweetheart, Brett. She soon became pregnant and gave birth to twins. Sandra's 2 daughters, her husband, Brett, and incidentally, her father, are all U.S. citizens. And by the way, this is based on a true story. Poll questions. You also have them written in your materials, but I'll read them out to you. Can Sandra get a green card? A, Sandra can definitely get a green card because her father is a U.S. citizen. B, Sandra can definitely get a green card because her husband is a U.S. citizen. C, Sandra can definitely get a green card because, taken all together, her father, her husband, and her 2 children are all U.S. citizens. D, Sandra does not need a green card because she is automatically a citizen, as her father is a citizen. And E, maybe Sandra can get a green card, but maybe not. We don't yet know enough about Sandra's situation. I'll give you 40 seconds. We should have music for this time. Ah. It comes in down here too. Only 133 people have voted? Come on, folks. There are more of you than 133. Okay, we've got 150 voters. The answer is E. All right, some people are listening. E. So I want to go over this. This story is a variation of one that's filmed of a group of people that a group in Washington, D.C. met in a detention center. And there was a young mother who entered the United States at the age of 4, married her high school sweetheart. Her father became a citizen. She had a child with her husband. And in fact, not only do we meet her in the film getting deported, but she was ultimately deported. In her particular case, she had come across the border at the age of 4, coming across the border without inspection. Her family had taken her across the border. And the mere fact that she had been taken across the border as a 4-year-old through no fault of her own meant that the fact that her husband was a citizen, her father a citizen, her child a citizen was not enough. So really important to keep in mind. Many immigrants in the United States live here with a number of family members who are citizens and green card holders, but there may be a barrier to them getting a green card. So this is the bottom line, and I said, a qualifying relationship is just not enough to get you over the line to the green card application process. So that's kind of a downer. So I'm saying here are all these relationships that may not work, but let's get to what might work, or let's get to how the process does work when it works. So there are really two kinds of family relationships for immigration purposes. There are what we call preference relatives, and there are immediate relatives. Before we get to those two kinds of relatives, I'm going to break down for you who can sponsor an immigrant. So U.S. citizens can sponsor many more family members than green card holders can. U.S. citizens who are 21 or older can sponsor parents, spouses, though of course only one spouse at a time, siblings, and children of any age, whether they are single or married. So citizens have a broad group of people who they are able to sponsor, but again, they have to be 21 before they can initiate the sponsorship process. Next, LPRs, another term for green card holders. Green card holders can sponsor spouses, again, one at a time, and unmarried children. So if you're a green card holder and your child gets married, that's the end. There is no sponsorship of a married child of a green card holder. You'll also notice green card holders cannot sponsor their parents and cannot sponsor their siblings. So it's a much more limited group for green card holders. For many people with green cards, their motivation to become a citizen is to allow them to be able to sponsor close family members who don't fit into this small group. So what kinds of relationships qualify? So first of all, you need to have if it's a marital relationship, and that works for both citizens and green card holders, you need a legal and valid marriage where the marriage takes place. So you are generally following the laws of the marriage where it takes place. What is a valid marriage in Belarus? I don't know. But once I find out what that is what's going to be a valid marriage for immigration purposes. What's a valid marriage in New York? Well, I can tell you, it certainly is not a common law marriage. We do not have common law marriage. So the mere fact that you live together or that you have children together does not make you a married couple. It's a legal, valid marriage. Unfortunately, and I see this a lot in my work, many people get married after they've been married before, but they forget to get divorced. That is not, if you're moving on to husband or wife number 2, but you forgot to divorce husband or wife number 1, that is not called a valid marriage. That is called a commitment ceremony, and that's not going to work. You can't marry someone for the purpose of obtaining a benefit. I think a lot of people are very clear that if you pay for someone to marry you, that's not going to work. But it's important to keep in mind that you can't simply marry a friend. You have a friend, you want to do them a favor, you're both single, and so you think, I'll marry them. That is very, very illegal, and it's not going to work for a marital sponsorship. Bigamous marriages and polygamous marriages, also not acceptable. There are some countries where, that I'm aware of, where men can have more than one wife, and so that would be a valid marriage in that country. Not going to work for immigration purposes. And similarly, though I don't know of any country where a woman can have more than one husband, and I don't know any women who want extra husbands, one tends to be more than enough. It's not going to work for immigration purposes. Perhaps for me and for many people, one of the saddest things is that right now a same-sex marriage, which is maybe valid in New York, which is definitely valid in New York, valid in Massachusetts, is not going to work for immigration purposes under the Defense of Marriage Act. So many of us are watching their court cases challenging. There may be a change of law, but for now, a valid same-sex marriage is not going to work for immigration status. Who is a child for immigration purposes? This is a tough one. It's not as straightforward as you would think. A child is someone, so the sort of general cutoff age is 21, somebody under 21. However, there are a variety of cutoffs going through the system about events that occur at 14, 16, 18, and in certain kinds of cases, as late as 25. So this is going to be a situation where it's tricky. There's some information about the Child Status Protection Act in your materials, but you're going to want to be careful when it's anything a little bit tricky. Someone's over 21, can they still benefit? There's an adoption relationship, a stepchild, step-parent relationship. These are going to be a little trickier, and you're going to want to be sure when you're when you're working as a call-in worker to check with a supervising immigration attorney. You can go over the nuances of the situation. And then the sibling, the basic requirement to keep in mind is that siblings have to have at least one parent in common. And again, there are some slightly complicated situations involving step-parent, stepchild, and the benefits for siblings, and as well as some slightly complicated situations for adoption. As I said before, there are two kinds of families. I like to think of them as two flavors of families. There is the immediate relative group and the preference relative group. The immediate relative does not mean what it means in regular English. I think of myself as having many immediate family members, but I have no one who would be an immediate family member for immigration purposes. So it's a very specialized phrase, and so you want to keep that in mind. It has a special meaning. Then there's something called the preference relative, which the US government has helpfully organized into 5 categories called 1, 2A, 2B, 3, and 4. Not how I count to 5, but that's how the US government counts to 5. So you're going to keep in mind there are these 5 preference relative categories. So who is an immediate relative? An immediate relative can be someone who is a spouse of a United States citizen, an unmarried child under 21 of a US citizen, although as I mentioned, there are some times when you go past 21, you may still be an immediate relative, and parents of US citizens who are 21 or over. That's your immediate relative crowd. Who are the preference relatives? They are as follows. Preference category 1, the unmarried child of a US citizen who is 21 or over, sometimes called the unmarried son or daughter. Preference category 2A, the spouse or unmarried child under 21, though again, a soft 21, of someone who is a lawful permanent resident, spouse or unmarried child of a green card holder. Preference category 2B, the adult unmarried, and I want to stress, unmarried son or daughter, 21 or over, of a lawful permanent resident. Preference category 3, the married child of a US citizen regardless of age. So for example, if you are 17 and married, then you would be in preference category 3 with respect to your US citizen parent. The age doesn't matter, it's the marital status. And preference category 4 is the sibling, the brother or sister of a US citizen. By the way, I'll just mention why we say unmarried in immigration law. There are many ways a person can get to be unmarried. You can be unmarried by never getting married. That's the easiest way to be unmarried. But you can also be unmarried after a legal divorce, a legal annulment, or the death of your spouse. So you can flip back and forth between a married and unmarried category if your marital status changes. So as I mentioned, turning 21. Not only do you get to drink, which is a plus if you like drinking, in this country, but the downside for many people is that they're going to lose the opportunity to be sponsored by a family member, or the way that it would work out is going to change. There may be a longer wait for the person after their 21st birthday. There are, as I mentioned, some tricky rules around the 21st birthday, predominantly under the Child Status Protection Act, but also under other provisions of Immigration and Nationality Act. So you're going to want to check in with an experienced immigration attorney if you are not already one, on whether or not somebody over 21 may maintain benefits like a person under 21. So immediate relative, what are the benefits to being immediate relative? So number one, and this is a huge benefit, as long as you have a lawful entry, and there are exceptions, some people even without lawful entry, as you'll learn later, might be able to benefit from this rule. But the general rule, barring an exception, is that if you enter the United States lawfully, then you can apply for a green card from within the United States, go through the adjustment of status process. If somebody doesn't know if their entry was lawful or not, you're looking for words like admit or parole. Those are the two most common words you're going to see on what is a lawful admission. The benefit number two, and this is huge, is there is no waiting line to apply for a green card. If I marry a non-citizen tomorrow, I walk away with my marriage certificate, I can file a sponsorship petition for my husband the very same day that he files a green card application. No waiting line at all. And that's huge, because what that means is I will not need to be separated from my new husband for several years. The downside, and this is a big downside, and we'll see how this works out, is an immediate relative doesn't get to bring along their spouse or their children at the same time. So if I'm a citizen and I'm sponsoring my husband, then he doesn't have any other spouses to sponsor. But for example, if I were sponsoring a parent, they do not get to bring around their spouses and their kids at the same time. So that's a bit of a downer. So let's go over this. Here's our next case study. Tanya is 27 and she just became a US citizen. Tanya is sick of living alone. Tanya hates washing dishes, pile up in the sink, and laundry pile up on the floor. Tanya can barely figure out how to heat her frozen dinners in the microwave. Poor Tanya. Now that Tanya is a US citizen, she wants to sponsor her mother, Martha, for a green card, so that her mother can come and live with her and solve all these problems. That would be great. Martha lives with Larry, her husband of 5 years, Tanya's stepfather, and her 12-year-old son, Tom, Tanya's brother, in their native Iceland. None of these family members have ever been to the US, nor have they committed any crimes. They have no inadmissibility barriers to applying for green cards. So here are your possible answers. There are 4. And again, you have them as well in your materials. A, if Tanya files a family sponsorship petition, her mother Martha will be able to apply for a green card and move to the US and in with Tanya. Yay! Just as soon as Tanya's family sponsorship petition is approved. But Martha's husband Larry and her son Tom will have to stay behind. B, if Tanya files a family sponsorship petition for her mother Martha, Martha will be able to apply for a green card and move to the US just as soon as Tanya's family sponsorship petition is approved. Martha's husband Larry and her minor son Tom will be able to apply for green cards at the same time and move to the US with Martha. C, if Tanya files a family sponsorship petition, even before the petition is approved, it will take years, even after the petition is approved, it will take years before Martha will be eligible to apply for a green card and move to the US. D, if Tanya files a family sponsorship petition, her mother Martha will be able to apply for a green card and move to the US just as soon as Tanya's family sponsorship petition is approved. Martha's husband Larry will have to stay behind, but Tom, as a child, will be able to apply for a green card at the same time and move to the US with Martha. Okay, let's take another 40 seconds. Okay, we're at 150, and that's a little bit more than 40 seconds. The answer is A. Yes, again. Where are we? Is that our results chart? 100% got this right?
No, 60%.
6%. 100%, all right. So the answer is, and this is, this is a real barrier to family reunification. Martha may be happy to join her daughter Tanya in the US, but unfortunately, she's going to have to leave her husband behind. She's going to have to leave her 12-year-old son behind. And for a lot of people, that's just not worth it. Many immigrants endure years of family separation, but for some people, it's just not going to work out. So the family sponsorship through an immediate relative, no waiting line for Martha, but she can't bring her family with her. Moving on, the preference relatives. There's a lot of downsides to being a preference relative. One, preference relatives have to wait online for several years. And they're supposed to wait on that line, by the way, all outside the United States. Not that most of them do, but that's the theory behind it. Generally, and again, there are some exceptions, some of which we'll discuss later this morning. Generally, if you've entered the United States without permission, snuck across the border, or worked in the United States without permission, or you've lived in the United States without permission, you're not going to be allowed to apply for a green card from within the United States. You're going to be forced to go abroad when you get to the front of the line. Unfortunately, once you go abroad for consular processing, you're going to run into other barriers that kick in only when you go abroad. So it's a catch-22. You can't be here, you can't go abroad. So getting to the front of the line for many preference relatives does not actually bring them closer to getting a green card under current law. There are some benefits. The biggest benefit for a preference relative is that they can bring along their spouse and their children. So with respect to children, every single preference category, 1, 2A, 2B, 3, 4, all of those categories allow you to bring your children with you, and preference categories 3 and 4, in addition to your children, allow you to bring your spouse with you at the same time. So the plus side is when you finally get to the front of the line, if you're eligible to apply for a green card, it's not just for yourself, but for your children who are unmarried and under 21, and your spouse if it's preference category 3 or 4. So how does this system work? I'm going to try to walk through it. It's a little bit hard to get your head around, but I'm going to try to do this slowly and try to stay with me. So family sponsorship begins with a family sponsorship petition. It's called the I-130. The I-130 is used in virtually all cases, whether you're going for an immediate relative sponsorship or a preference relative sponsorship. Note there's something about fiancés, but we're not going to have a chance to cover it. So for people who are already your relatives, your spouse, your children, your parents, your siblings, it's the I-130. This is used whether you're applying for a green card from within the United States or from abroad. What does the I-130 do? This is the family sponsorship petition that is going to establish that there is a citizen or green card holder who's called a petitioner, and they want to sponsor a family member who's called the beneficiary. So it's going to establish the immigration status of the petitioner, as well as the qualifying family relationship with the beneficiary, that they're parents and children, husband and wife, brother and sister. The form is available on the USCIS website, and it currently costs $420, but note the prices change all the time. As of today, it is $420. Again, it is not filed by the immigrant themselves who would like to get a green card. It's filed by the person who is already a citizen or green card holder. After the I-130, a lot of things can happen. The petitioner's immigration status can change. For example, they can go from green card holder to citizen, or they could go from green card holder to deported person who used to be a green card holder. A beneficiary's age can change. They can go from somebody who's under 21 to somebody who's over 21. For everyone who doesn't die by their 21st birthday, that's inevitably what happens. One day they will be over 21. And then there is a change in the beneficiary's marital status, which can be a huge buzzkill, as it were, to the I-130. And it certainly can change things. Or the person could be married at the time the I-130 is filed, and they can subsequently become divorced or widowed. These changes are going to do one of two things. Either it's going to change someone's preference category, either within the preference category, or change them from a preference relative to an immediate relative, or an immediate relative to a preference relative. In some situations, it's actually going to be the end of the I-130, and the I-130 will be no more family sponsorship petition at all, depending what the change is. Here's a few more things to know about the I-130. If the I-130 petitioner dies after filing the I-130, in some situations, really expanding number of situations, there's a way to still capture that I-130, and the would-be beneficiary of the I-130 may still be eligible for a green card. Again, we're not going to have a chance to go into how those rules may work today, but it's something to keep in mind and something to consult with a supervising immigration attorney. And again, sometimes the I-130 is filed by a petitioner who is abusive, and there is a domestic violence situation. In domestic violence situations, both those involving an I-130 and a variety of domestic violence situations, there may be other options for the victim of domestic violence that are not dependent on an abusive citizen or green card holder sponsor. So here is a case study, and you'll forgive my pronunciation. Madhu is a lawful permanent resident, a green card holder, and she filed a family sponsorship petition for her son, Anil, several years ago. She is thrilled because she has just learned that Anil's priority date is current. That means he has gotten to the front of the line and it's now his turn to apply for a green card. She hopes that her son, who lives abroad, will be able to apply for and complete the green card process and enter the United States by the fall. You run into Madhu and she shares this information with you along with a final piece of good news. Her son Anil is engaged to Archana and his wedding is only 2 weeks away. What do you say to Madhu? A, Mazel Tov. I can't wait to meet Archana and Anil when they move to New York in the fall after completing the green card application process abroad. B, that sounds great and all, but have Anil and Archana considered a commitment ceremony or just exchanging rings out of a Cracker Jack box or something? C, I think if Anil, by the way, C, I think if Anil and Archana get married before Anil gets his green card, it will set him back in the waiting line and it will take longer for him to get to the front of the line to apply for a green card. D, does Archana have a sister? I'm looking for a new girlfriend. And E, if the couple marries before Anil completes his green card application process and gets approved and comes to the United States, your family sponsorship petition is dead in the water. 40 seconds. Okay, the correct answer is E, but B is also correct, in a way. I would take B a little bit of B. So let's go over this. I see overwhelmingly we went with E, and I want to stay. So E is technically absolutely correct. If Anil gets legally married before his green card application is approved, and he comes to the United States, his sponsorship form is dead in the water. B, if he exchanges the Cracker Jack rings, he's probably still good, because that's probably not a legal and valid marriage in any jurisdiction that I'm aware of. There is something called fraud not married, where people really do have a marriage and they get, but they hide it from immigration authorities. That can come back to haunt you. And that can come back to haunt you 15 years later, 20 years later. So it's best to just stay away from the marriage, even a fake ceremony. Stay away from the marriage altogether until such time as you get your green card. Because here, Anil is the son of a green card holder, and so there is no category for married child of a green card holder. So that would not work. So E is the really best answer. So how does the system work? I just want to get down to some of the nuts and bolts. So if the non-citizen is in the United States and eligible to apply for a green card, the citizen's I-130, the family sponsorship petition of the citizen, can go in the very same envelope, the very same package as the green card application itself. Everything can be submitted together, and a decision can be made at an in-person interview all together at the same time. If the non-citizen is outside the U.S. already, if they are required to travel abroad to apply for a green card, or if they choose to, there's no requirement that you process it in the U.S., so they choose to go outside and files an I-130, that process takes about 5 months for the I-130 to be filed, and then the would-be green card holder can begin the process from abroad. Again, if you're in the U.S. and leave, there may be some extra barriers, extra reasons why you're not going to be eligible for a green card. So I wouldn't send anyone abroad voluntarily without a careful analysis of whether or not they're going to be able to get their green card from abroad. So if you're in the U.S. and eligible for a green card, it can be a one-step process if you choose to make it a one-step process. How the preference system works. So this is the part that gets a little bit more tricky. The date that USCIS receives your I-130, which is usually a couple days after you file it, put it in the mail, is called the priority date. The priority date is your placeholder online, the day it was received by the I-130 was received by immigration. The expression we use in immigration to say you've gotten to the front of the line, it's now your turn to apply for a green card, that expression that we use is called current. We say your priority date is current. There's no green card application that comes in the mail. There may be no reminder that comes in the mail. It's simply that when you are at the front of the line, your priority date is called current, and you're eligible to apply for a green card. Again, possibly facing some of the barriers we've talked about or some of the barriers we haven't talked about today. So what I want to do in our remaining minutes is talk to you about how you identify the priority date, how you figure out what it is if somebody else comes to you and says they've filed the I-130 already, and then how you monitor it. The place that you monitor is called the Visa Bulletin. You have a big fat Visa Bulletin in your folder. They come out every month, and you can find them every month on the State Department website. I've typed out the whole address, but if you just Google State Department and Visa Bulletin, you will find it very quickly. So with respect to the waiting line, what's important to know is that it doesn't move at the same rate every month. Sometimes it moves really quickly, sometimes it moves really slowly. And depending on what country the would-be green card applicant is from, it can move extra slowly. So we'll look at that in a moment and see how that works. So what you're going to be looking for when you're looking at an I-130 receipt or when you're talking to someone over the phone is a piece of paper that will say somewhere on the top form I-797. There may or may not be a letter after 797, and then it will say notice of action. There's going to be a section that is called notice type or preference classification, and that's how you're going to figure out whether the person is an immediate relative or a preference relative, and if a preference relative, which preference category. And then there's going to be a section called priority date, and that's going to show, you guessed it, the priority date. So let's look at a couple of notices. So these are a couple of notices in cases that I've recently been involved with. And you'll see here on the top, you see 797 with a C, and notice of action. The C doesn't really matter. And you see case type, I-130. We're going to look at another document which calls the I-130 something slightly different, but you're looking for I-130. You're going to see a priority date, so we know the priority date here is April 24th, 2011. And it says preference classification, sibling of USC. And we know preference category 4 is the preference category for a sibling of a USC. So that is what we're going to know. So if you're talking to someone on the phone and they say, oh, someone filed something for me, you're going to ask them if they have the notice of action. This is what you're looking for. I'm going to show you another one, looks slightly different. This is an approval notice. And again, you're going to see a notice of action on top. Case type is I-130, described slightly differently. Priority date, February 19th, 2012. And then you're going to see its approval notice, and it says parent of USC. Now, a parent of a USC is an immediate relative, so they don't even need a priority date because immediate relatives don't have to get online, and yet they're going to fill that information in anyways. That does tell you when the document was filed. Here's a snapshot. This is the most important part of the visa bulletin. And I'm going to ask folks, because you're going to need them for all of the final questions, to pull out in your blue folder. You're going to find a document. It's a few pages long. It will say Visa Bulletin on top. And I think it has a Courier font. What? Not all of them are green. Some of them are green, some of them are another color, depending on who made the photocopy for you. And within that Visa Bulletin, you're going to find something. You guys have the April Visa Bulletin? So you're going to find a snapshot of the this is the family section, and that's the part you want to look at. As you can see here, people from China, people from India, Mexico, and Philippines, in certain situations, have extra long lines. The date that is listed on the Visa Bulletin means that if somebody filed their I-130 and got a priority date before the date listed, it will be their turn to apply for a green card. So the date listed is the cutoff. You have to have filed your priority date must be before the listed date for your preference category. So you'll see on the left column 1, 2A, 2B, 3, or 4. And you have to look at the country that the would-be green card applicant is from. And you have to say, have they gotten to the front of the line? Is their priority date current? So we're going to go over a couple of examples. Case study. Angela was born on August 4th, 1978 in Ireland. She is an Irish citizen. In the year 2000, Angela's mother, Rosemary, moved to the United States and became a green card holder. At the beginning of 2005, Rosemary became a U.S. citizen and soon thereafter filed an I-130 petition for her daughter. Her daughter's name is Rosemary. Her daughter is not Angela. Angela's the mom. Wait. Oh, I take that back. Rosemary's the mother, Angela's the daughter. So there was on behalf of the daughter Angela, I-130 was filed and receipted, and the priority date is March 5th, 2005. On September 9th, 2006, Angela, who was never married, gave birth to her only child, Seamus, who, like Angela, was born in Ireland and is an Irish citizen. Can Angela and Seamus apply for green cards and move to America? A, Angela and Seamus can both apply for green cards from Ireland, called consular processing, and then move to the United States as green card holders. B, Angela can now apply for a green card, but Seamus is not eligible and must stay behind. C, neither Angela nor Seamus can apply for green cards at this time. D, Angela would have been eligible to apply for a green card now if she had remained childless. So again, just going to flip back here. The date that the I-130 was received by USCIS was March 5th, 2005. You'll need to look at your visa bulletins to answer this question. Let's take 45 seconds. Okay, we don't have as many respondents, but we're going to have to move ahead. So let's look at the situation. The correct answer is A. And almost half of you got that. That is great for your first look at the Visa Bulletin. So let's walk through that and see how that is. Ireland, does Ireland get a special column of extra slow line? No. So we're looking under the column that says all chargeability areas except those listed. Rosemary's a citizen. Angela is her adult daughter. What family preference category are we in? We are in 1. For F1, for all chargeability areas, what is the priority date listed here? April 1st, 2005. The priority date on this I-130 is March 5th, 2005. So that's a few weeks before the cutoff time. So Angela's now at the front of the line, and she's able to apply for green card. As a preference relative, as I mentioned, one of the benefits of being a preference relative is that you always get to bring your children with you. They can apply for green cards at the same time as the principal beneficiary. So in this case, both Angela and Seamus get to be at the front of the line. Doesn't matter that Seamus is born after the I-130 is filed, that's fine. As long as the mom is, Seamus's mom, Angela, is in preference category 1, she's the principal beneficiary. Her son, Seamus, can go at the same time. Let's take another one. This involves the French. Jean-Jacques was born in Paris on July 14th, 1981. He is a citizen of France. In the year 2000, his father, Claude François, moved to the United States and became a green card holder. Claude François filed an I-130 for Jean-Jacques, which was received by USCIS on December 30th, 2000. So here's the question. Can Jean-Jacques apply for a green card now? We're running out of time, so you get 30 seconds. Like the birth dates? Okay, I'm going to go back to this, and the answer is yes. Yes. So again, is France one of the extra long line countries? No, it's not. If the dad has a green card and the son is an adult, what preference category are we looking at? 2B. 2B. 2A is spouses and unmarried children under 21 of green card holders, and 2B would be those over 21. Being born in 1981, the son is now way over 21. The current priority date, January 15th, 2004, and this case was filed December 30th, 2000. So he's been at the front of the line for a while, and he can now apply. I'm going to do one final quick case study to make a final point. So this is our final study. This is Andrew. He is a U.S. citizen, born February 3rd, 1965. He filed an I-130 for his sister Karen, a citizen of the Philippines, which was received by USCIS back on December 5th, 1988. That was a really, really, really long time ago, like 22, 23 years ago, super long ago. In 1990, Karen married Robert. On April 1st, 1995, Karen gave birth to the couple's son, Matthew. Note that Robert and Matthew, like Karen, are citizens of the Philippines, the only country where any of them have ever lived. Here we're going to say, what are the options for this family? Karen can apply for a green card, but Robert and Matthew cannot? B, Karen and Matthew can apply for green cards, but Robert cannot? C, Karen and Robert can now apply for green cards, but Matthew cannot? Or D, none of these three people can apply for green cards at this time? Final 30 seconds. A, B, C, or D? We can cut off the poll, and unfortunately, E, the correct answer, E is the correct answer, and it got cut off. So for those of you who said E, the answer is, and I don't know how E got cut off from the poll when I read it, but let's go back and I will show you how E can be the right answer. So, E. All of them can apply for green cards, every family member. So that was a trick question because the slide had an unhappy metamorphosis between the time I wrote it and the time that it got to you. So let me explain how this works. The line for the Philippines, for brothers and sisters from the Philippines, is very, very long. As you can see, it is a sibling is 4th preference category, and the Philippines is the current priority date is January 8th, 1989. That is a really, really, really long time ago. Maybe some of you weren't even born on that day. It's a long time ago. But when you get to the front of the line as a sibling, your spouse and your child, any of your children, can apply for green cards at the same time as you. Doesn't matter that the marriage took place after the I-130, doesn't matter that the children were born after the I-130. In preference categories 3 and 4, your spouse, including your after-acquired spouse, can come with you on can be part of your front-of-the-lineness. Everyone files their own green card application, but they can file with you at the same time. And your children born before or after the I-130 filing date, as long as they're unmarried, under 21 in reality, or can be counted as under 21 in child status protection age years, can come with you as well. So in that way, the benefit of waiting all that time is you get to bring your whole family with you. And with that, I want to thank you very much for your participation and for hanging in there with me.